Hello and welcome. In this video, we are going to cover the introduction of CPC, that is Code of Civil Procedure 1908. It is basically divided into 158 sections, 51 orders and rules, 8 appendices, and it is effective from 1909. So let's first talk about what is CPC. There are two kind of laws. One is substantive law, one is procedural law. Substantive law basically tells you the rights. Like for example, Transfer of Property Act tells you that you are the owner of your land. The procedural law on the other side tells you how to enforce those rights. So CPC is basically the rule book for every civil court in India. So CPC is basically a procedural law. It tells the judges, lawyers, and litigants how to start a case, who can sue whom, how to send notices, how to conduct a trial, how to appeal, and how to collect money or property on basis of the court orders. So without CPC, each court would make up their own rules, creating a lot of chaos. Like for example, cases in Delhi follow the same procedural law in Chennai because of CPC. So what counts as a civil matter? So any kind of a dispute which relates to the private parties and they have some rights involved or some property involved, so that is a civil matter. For example, recovery of money is there, property disputes are there, breach of contract is there, family succession, partition of land, compensation and injunctions. So one thing that we need to focus up over here is criminal matters like murder, theft. They are covered under CRPC, that is now BNSS 2023, which is not being dealt with CPC. Code of Civil Procedure is not applicable up over there. Coming on to why it was created. So the first attempt was made in 1859. It was not successful. A lot of shortcomings were there. So another attempt was made in 1877. Again, some shortcomings were there. Then 1882. Then coming on to 1908. So coming on to 1908, it was comprehensive, uniform, and flexible. And the draft which was made in 1908 over the period of time adding up with certain amendments, so it has survived over 115 years. Then come on to who can amend CPC. So it can be amended in two ways, one by the parliament, one by the high court. So if we talk about the sections, they can be amended by the parliament. If we talk about the orders and rules, so they can be amended by high courts, which is dealt under section 122. Then coming on to how CPC is organized. So there are two layers basically. The first layer is dealing with the sections, which is the backbone of this code, and the second layer is dealing with the orders and rules, which are basically the muscles of the code. Then it has 8 appendices, and the first appendix deals with the plaint, the second deals with written statement, third deals with the summons, fourth deals with the decree, fifth deals with execution, sixth attachment, seven appeals, eighth is miscellaneous form.